Welcome everyone to our latest in-house in focus session. A great pleasure to have you attending these seminars. I'm very pleased today that we're joined by Oliver Sweeney, who very grandly is the head of legal and enforcement and the head of legal policy at the SRA. So I'm not sure if anyone else at the SRA does any work, since he appears to be doing it all at the moment. And as you can see from the slide, he's kindly going to be talking to us all about standards and regulations and recent developments. I'm sure it will be of great interest because for many of us, most of us perhaps, at some point in our careers at least, we'll have to interact with the SRA. I hope it's not just me, and it's always important to have that understanding of our professional obligations. And I'm particularly interested, as my wife is an in-house lawyer, to just get a slight sense of the perspective of how these things may differ for the in-house legal community and where things overlap. So it should be a great talk. As you should have seen, it is being recorded, and the slides and the recording will be available afterwards for those who haven't seen it this time around. If you're watching it on recording, hello. If you're watching it again, well done. As we go through, please do ask questions. The plan is Oliver will talk for sort of 30 to 35 minutes, and then there'll be time for questions. Pop them into the Q&A box, not the chat box, if you can see that, please, but the Q&A box only, and we'll try and get through as many of those as we can at the end. You will also be asked for feedback on the talk and so forth at the end. Please do fill that in, and please do give us suggestions for what you'd like to see covered in these seminars, because that guides us in what we deliver in this program, since we want to give what you want to listen to. Any fire alarm you hear is entirely your business. It's nothing to do with us. So without further ado, I'm going to hand over to Oliver. Oliver.
Thank you, Simon, for that kind introduction. And hello, everyone. Good morning and welcome. So today I'm here to talk about the SRA's rules, how they apply to in-house lawyers in particular. I've got some updates on our recent work from this year, and at the end, as well as doing the questions, I'd be interested to hear what else we might do to help in-house lawyers in particular as an important part of our regulated cohort. So please do think about that as you do your questions, or think about your questions as we go through. Next slide, please. Most of you will be familiar with what we do, since we're likely to be your regulator. But on this slide, I've outlined our key activities. We also do other things like operate a consumer protection fund, and we carry out interventions into abandoned firms. You'll see how many solicitors we regulate, and of those, just under, at last count, 37,000 work in-house. So as I said, you are a very important group to us, increasingly so. Next slide. Most basically, practicing solicitors should all be aware of our standards and regulations, which we updated substantially in November 2019. The key things that you'll want to be aware of are our principles and our code of conduct for solicitors, both of which are published on our website. Those are the key rules we make, and they're made further to what the specified regulatory objectives set out in the Legal Services Act, which include protecting and promoting the public interest, the rule of law, upholding and maintaining the rule of law, improving access to justice, encouraging a strong, diverse and effective legal profession, and promoting and maintaining adherence to professional principles, which include things like integrity, independence, acting in the client's best interests, all of which we'll return to later in this talk. In terms of the revisions made to the rules in November 2019, those were made to make the rules a bit simpler. They're a bit more user-friendly. For in-house lawyers in particular, the code of conduct has been split into a conduct code for individuals and for firms, so it's a little bit clearer which parts of that are particularly relevant to you. And also there's a bit more practicing flexibility for those who want to act as freelancers. I do also have to mention the accounts rules, but they're unlikely to be as relevant to in-house lawyers because you won't be holding client money. On the next slide, please. We mentioned the principles, and these are the key ethical tenets which we expect solicitors to uphold, and they're listed there on the slide. There's now 7 of those. and hopefully they're not too controversial. But obviously, we do. A key part of our role is to take action where these principles are breached by individual solicitors. It's worth mentioning, by way of an update, that there has been some recent developments around the scope of those rules insofar as they apply not just to acts done in the course of legal practice, but also potentially into a professional's personal life. Classically, I mean, this has happened for a long time, but classically it's been something like a solicitor gets convicted of a serious criminal offence like fraud if they misappropriate funds when they're a school governor or something like that. And it's pretty obvious why that would breach the integrity principle and also fail to uphold public trust in the profession. But there's been some more recent case law which is related to more novel areas, if I can put it that way, often arising out of things like the prominent use of social media to express views which do not encourage equality, diversity, and inclusion, to put it mildly. And also in relation to sexual misconduct, including the use of non-disclosure agreements to settle such claims, which have been of concern to us. And the recent case law on that has provided a little more clarity about when and how we can intervene into actions done in a private life. And we've tried to set that out for the benefit of the profession. And I set out our approach in some new guidance we published or updated in September this year. That's our guidance on integrity, on sexual misconduct, and on convictions arising from principled actions, which I'll come back to later in this talk. But essentially, we can regulate where the conduct touches realistically upon the individual's practice of the profession in a way that's demonstrably relevant. And what we'd have to do is, in the individual cases, explain why we think that conduct is relevant to professional practice. Next slide, please. As well as the principles, we've got the codes of conduct, particularly the code of individuals, which will apply to you. I've got to illustrate the sort of difference between the codes and the I've just lost my slide. To illustrate the difference between the code and the principles, the code of conduct is a bit more. It's still quite short compared to the handbook, which we had before, but it's a bit more prescriptive in the sense it says things like you must not mislead the court, you must comply with your undertakings, and there's a series of requirements in there which you can have a look at if you're not familiar with them. Previously, there was lots of non-mandatory indicative behaviours, they were called, which offered examples of how you might comply with outcomes like avoiding conflicts of interest. That was viewed as being overly prescriptive, so they're no longer in our code, but we do supplement the code with guidance, particularly on grey areas, as I've just mentioned. So some guidance which will be useful to you we publish is around conflict of interest. We publish guidance on putting matters right where they've gone wrong, and on how and when you need to report concerns to us. I do just want to address, since I think we had a query about it, the legal status of our rules. The principles and codes and our other rules are made by our board in the exercise of our statutory powers to impose those requirements, so they do have the force of law. And where that's often relevant is if a question arises as to whether or not you're allowed to process personal data or confidential data based on there being a legal obligation to do so, which might arise in this situation out of compliance with your regulatory obligations. So that's, I mean, that's what happens when you join the profession. But before you join the profession, we do obviously also do the whole regulatory life cycle. So on the next slide, I wanted to mention the solicitor's qualifying examination, which is another relatively recent development. First was introduced in September 2021, thank you. And the first exams were held this year. The reason for introduction essentially is it simplifies the route to qualification as a solicitor, improving accessibility as well, hopefully, whilst of course maintaining standards. And some of the key benefits are set out across the next two slides. If I may, next slide. I think from the point of view of in-house lawyers, obviously you need to be aware that this is now the key route to qualification as a solicitor. There is a link to our resources set out on one of the later slides if you have any practical questions about SQE. One thing which I think may be relevant to in-house solicitors on the next slide is relating to qualifying work experience, which effectively you're going to be doing instead of a training contract. That is in line with the rest of the SQE, a bit more flexible than it used to be. So There's still some very clear requirements, but the focus really is on developing the competencies which are set out in our statement of solicitor competencies. So we've dropped some of the existing requirements, and that's probably important to understand if you are taking on what we used to, I suppose, think of as trainees. So that's what I want to say about the framework. If we can move on to talk about in-house solicitors specifically and how our framework applies to you. Next slide, please. I understand, being an in-house solicitor myself, that in-house solicitors typically have two roles. You're both someone we regulate, but you're also a service user. And I want to look at the first aspect first, if I may, the service user aspect. So most obviously, our regulation assists you in providing professional standards and ensuring those standards are upheld. And of course, if you see there's any breach of those standards, conflicts of interests, failing to act in your best interest, you can report that misconduct to us. There's a number of other things we do which might be of use to you. I'm going to mention at the end our published resources, which include some research into things like the state of law tech, hopefully which is useful to the profession as a whole. We make some prescriptions in our codes for firms which may be of use to you. So obviously you'll be aware that firms have to provide specific client care information. They have to carry minimum required indemnity insurance. There's also some newer requirements such as the transparency rules. These were introduced the other year in order to improve price transparency, particularly because only 18% of law firms were publishing price information in 2018. So we've introduced a requirement to publish price information for certain specified services. That includes residential conveyancing, probate, immigration, employment tribunal work, and debt recovery up to a value of £100,000 plus licensing applications for business premises. So you should now be seeing that on law firms' sites if they offer those services. The other thing I wanted to mention was the solicitors register. This is a searchable register of solicitors that we regulate. And we'd obviously recommend this as a tool to find out about solicitors you're dealing with. So that might include those on the other side of a transaction, but also particularly if you're doing any due diligence on prospective employees. And just a quick shout on this, please do make sure you use our website directly. We do occasionally get people who are using the information just as suggested on Google, and that's not necessarily always going to be comprehensive and accurate. So please do take advantage of the solicitors register on our website. So hopefully that's all useful. But now I want to move on to the second aspect, which is how you may work as a regulated professional. Now, Simon said at the outset we're going to sort of think about the particular quirks of working in-house as a regulated individual, and so that's what I'm going to try and focus on. But it's worth saying that there's no subset of rules that only applies to in-house lawyers. So in terms of the principles and the code of conduct for solicitors, that will apply to you in the same way it applies to when working in a firm. There are additional rules which apply to regulated firms, which I've mentioned, but the ethical concepts governing a solicitor's role and behaviour apply equally to in-house solicitors. However, working in-house might come with different considerations as to conduct and risk. You might not get the same level of support in terms of a compliance function as a larger firm. You also might be thinking about, well, you have to comply with your own personal requirements, but you'll also be advising your employer on their own compliance with their laws and regulations which apply to them. So you might be regulated by the FCA. They may have reporting requirements to Treasury. They may operate fleet vehicles. They'll have health and safety requirements, etc. And whilst the compliance with that might be the responsibility of your employer, the way you advise on that is going to have to reflect your own regulatory obligations. And we're going to look at a few examples that illustrate that over the next few slides. So the first of those principles I want to look at is independence and how that applies to the in-house solicitor. Typically, you're going to have one client who is also your employer. So that's obviously different from firms who work for multiple clients and are organisationally separate. I've mentioned on this slide a few things which could crop up and cause questions around whether or not you're able to and indeed are acting independently. I would recognise that there are practical and probably also emotional challenges of giving the same advice you might if you're an external lawyer, where the advice you'd be giving might be to your boss, who is the subject matter of the advice, and that's an obvious risk which we'll come back to. But I think the reason I wanted to start with this really is that there's been quite a few high-profile examples of this in relation to in-house practice recently. I was going to mention the RICS governance issues regarding their non-executive director, and the Post Office Horizon scandal, both of which you may well be aware of because they have been quite high-profile, and there's been quite a bit of academic comment on each of those matters. Pending, obviously, some of the further investigations and the inquiry which is currently going on, for instance, in relation to the Post Office. But some of the embryonic conclusions of those academics are around the lack of clarity and focus from the lawyers on who they're acting for, and trading off ethical requirements against the perceived business requirements of their direct bosses. So if you're not already aware of these incidents, I think it's a good thing for in-house lawyers to be aware of and to track, as in particular that Post Office inquiry goes through its motions. On a related note, one of the first things you need to identify, as on the next slide, is who is your client. It may seem obvious, and sometimes it will be obvious, but if you don't know who your client is, it's difficult to act in their best interests and to avoid conflict of interest. So a lot of things flow from knowing who your client is. Typically, that's going to be your employer. But note that your instructions will come from an individual who is not necessarily your employer. And the classic example of this is you may get an investigation into alleged misconduct by an executive. That executive may be involved in instructing you on it. That's not ideal for fairly obvious reasons. So you need to think about, actually, is your client really, or the person who should be instructing you, someone from the board or the board directly? Do you need to be able to bypass certain individuals when advising, in order to both maintain your independence and properly advise your client as identified? The other aspect that this can come up in for in-house lawyers is where you've got large group structures. You may be advising, you may need to be clear on if you're advising group or a subsidiary, and there is a risk of conflict there, which I'll come back to. So having identified who is your client, you do need to act in their best interests. This is, in theory, very straightforward, since that should be what you're aiming to do. The issues that come up with this more often are how that gets balanced with other duties and public interest considerations. And our principles are explicitly explained to be subject to consideration of the wider public interest. So there is principles around upholding the rule of law. Obviously, misleading the court would be quite serious, even if you perceive that was in your best interest of your client, and upholding the public confidence in the solicitor's profession, and those will take precedence over an individual client's interests. So this comes back to the ability to maybe say no or push back on certain requests, and something which we might want to discuss later is to what extent employers are understanding or can be made to be understanding of that need to uphold your own professional obligations first. One very obvious example of this is set out on the slide. It is not, sadly, uncommon in our case law for people to be put under pressure to backdate documents. It's not limited to in-house solicitors, I should add, but it is a pretty clear example of professional misconduct. So no matter if everyone's nodding in the room, that is not something we'd expect a regulated solicitor to accede to. Moving on, the next slide, we talk about conflicts of interest. Again, in theory, more straightforward for in-house solicitors because you typically have one client. But this comes back to, are you identifying who your clients are? So in a group context, you may be asked to act for the subsidiary, and it's to be guaranteed by your parent company, who is actually your employer. So in that scenario, you're potentially acting for two clients. Now, there are actually exceptions to the code rule mentioned there, which allow you to act when you perceive there is a risk of a conflict of interest. And the one which will come up most often for you, I suspect, is the substantially common interest exception. But there are a number of requirements to fulfill if you want to use that exception, including that both clients are informed of it and give their informed and clear consent in writing. And you may need to put other safeguards in place. There may also be risks which arise out of you being privy to confidential information on both sides of the coin, which is very difficult to manage, and that's where you start to think about information barriers, and indeed, could you ever act in that scenario? You may need to put someone else in place who has an information barrier. And overall, it still has to be reasonable for you to act. So if you can't realistically act in their best interests, you can't rely on that exception. So, for instance, here you may well be at the outset perfectly able to act relying on that exception, having worked through the conditions. But if something goes awry, or for instance, there's a disagreement fundamentally about the nature of the agreement or the terms, it may be that you would have to say, I can't continue act for both of you, or indeed potentially either of you, depending on what you've been privy to in the course of that negotiation. So that's just a risk to remain alive to, I think, in that context. The next thing I wanted to mention was systems and controls. Now, the specific requirements on firms in their case to have systems and controls. So for individual lawyers or lawyers working in an in-house function, it's more about considering what controls you realistically need in order to ensure that you act in accordance with your regulatory obligations, and you're recording that. So, for example, using the example I've just given around the substantial common interest exception, if you were to rely on that, you would want to say consciously, I am relying on this, and you might want to say, this is the date on which I obtained informed consent from this client. This is when I did it from the other client. Here's the evidence of that. I thought about whether or not it's reasonable to act for both of them. I can do it in their best interest, and I have. And you might want to record all that down. The other thing where you might be able to consider systems and controls which would help you are around governance concerns. So, for instance, how is whistleblowing dealt with in your organization? What is the scenario where you are able to talk to someone other than your direct line manager about something that you are concerned about? That might be something which you could find useful. Obviously, hopefully it doesn't come up very often, but there's nothing worse than being in a pickle and not knowing what to do about that. So it's something that you could think about. The next aspect which I wanted to draw out as particularly relevant is supervision. There are specific code rules regarding supervision. So where you supervise or manage others' works, you remain accountable for the work carried out through them where it's legal services, and you have to effectively supervise work being done for clients. And you also have to ensure that the individuals you manage are competent to carry out their role and keep up their professional knowledge and skills. This is pervasive in some senses because, of course, where you're managing a team, the outcomes that you're getting often are dependent on your supervision and ensuring that team has competency. So it is something that we're considering as an area of particularly current focus. It's also relevant to what we're looking at with a bit more intensity around poor workplace cultures and mental health issues arising. Often that can be exacerbated by a lack of quality supervision. So it is an area of interest for us at the moment. And we've got new guidance which should be coming out later this month on supervision. So do look out for that. On the topic of new guidance, there's been quite a lot come out this year or recently, which I just wanted to walk through because and I say this isn't the full list, but this is the stuff that I think would be particularly interested in in-house solicitors. The guidance on workplace environment and the risks of a poor workplace culture came out in February, together with a piece of thematic research on best practice in ensuring and promoting positive workplace culture. And the guidance sort of focuses on, well, what are the risks of that? We don't say we will prosecute you if you have a poor workplace culture, but if that poor workplace culture leads to people cutting corners, backdating, falsifying documents, solicitors are having breakdowns across the piece. These are the sort of things that we need to start looking at. The guidance focuses on that, but the thematic work I think is really useful because it brings out what firms are doing to promote good workplace culture, and that's things like role modeling, positive behaviours, support for staff counselling, again across the piece, not just the employees but also managers and how they're being supported. So that thematic is definitely worth looking at. Non-disclosure agreements I've touched on already. We updated that since its first publication to capture the fact that NDAs can be of a concern other than just in employment disputes, if essentially again they're preventing the reporting of, say, fraud to the police or misconduct to us, and also to cover things like clawback clauses, which have the equivalent effect of an NDA. I mentioned the pieces on integrity convictions arising from matters of principal and sexual misconduct. Those were either issued or refreshed in September, and do each cover off some content relating to conduct outside of practice. So maybe worth having a look at for that reason, if nothing else. And I just wanted to mention as well the updated conduct in disputes guidance. Now, that's the key point of that guidance is how you balance off your best interests, or acting in your client's best interests with your obligations to the court and others to public interest. It now includes reference to SLAPS, which, for those who are not familiar with that issue, means strategic litigation against public participation. Currently, there's some proposals that there may be new legislation around that, but essentially, the point is that we don't want to see abusive litigation tactics, which basically have the intention of hiding away legitimate allegations and legitimate use of the freedom of speech. So that's mentioned in that guidance, and there's going to be hopefully within again the next month some more specific guidance on SLAPS. So I thought I'd best mention that, not least because I think that could be an area where in-house lawyers might be pushed into acting despite not being defamation specialists by the day job. So it might be useful for those purposes. And I think I mentioned again at the end, I'm going to ask what you'd like to see, what might be useful to you from us, so we can pick up maybe the topic of guidance at that point as well. So moving forwards, I wanted to cover off reporting of concerns and enforcement. So it's probably worth highlighting again that all our requirements apply equally to those working in-house, but it's worth mentioning we don't tend to receive a lot of reports on those working in-house compared to those in private practice. We're not entirely clear on why that is. It could be we over-rely on direct contact with the general public to provide us with intel. It could be you're working in a lower risk environment. So for instance, you're not holding client money, or it could just be that there's a better quality of conduct by in-house solicitors. Hopefully it's the latter. But that's not to say that situations don't arise where your working life can give rise to concerns. That could be concerns with your own conduct, which you do have to self-report, conduct of members of your teams, conduct of the other side to a negotiation, or conduct of those firms that you instruct. Again, in terms of sort of the support we provide, there are rules in both codes which set out your requirements to report to us and some helpful guidance on this point. In terms of the guidance, on the next slide, this was something we updated in line with the updated rules in 2019. We changed the focus from having to report serious breaches to reporting facts or matters you reasonably believe are capable of resulting in finding a serious breach. So that's to make it a little bit fairer, and it does necessitate a bit of understanding around what's a serious breach, and we touch on that in our enforcement strategy, which I'll come to later. Another key update there was making it clear that subjecting anyone to detriment for making or proposing to make a report to us would itself be misconduct, which is a fairly important whistleblowing principle. So we recognise that making a decision to report to us can be quite uncomfortable. We do try to provide guidance which supports you in deciding when to do that. We ask that reports are made to us promptly once you have this reasonable belief, but we accept that's going to be used for your judgment. You might need to investigate matters before you can reach that decision, but in fact, once you get to that point, it may not be at the end of an investigation. You might need to continue an investigation after you've got enough info to make a report. That's something we accept, and often we will get reports to us which come together with a statement that we're still investigating this, and obviously we give that due deference. And in terms of your reporting obligations, these are set out at the codes of conduct from 7.5 onwards. And I just reiterate that point I made earlier that these are legal obligations, so that they can override the requirements for confidentiality. And we believe that provides a legal basis for information sharing with us. again, hopefully that's useful to realise. In terms of the what we do with intel when we get it, well, we get 11,000 to 12,000 complaints per year, and we do want to focus on the right things and take action that's needed to protect the public, maintain standards and uphold confidence. So we're not going to be interested in everything that comes across our desk realistically. So we're not interested in minor or technical breaches, things that are simply errors of professional judgment, and go no further than that. And we don't want to try and punish people who are basically clearly trying to do the right thing. Sorry, next slide, please. Key factors which might aggravate or make something serious if it wasn't before was an improper motivation. So, for instance, dishonesty, risk of serious harm to clients or the public interest, and failures to take any necessary remedial action. And there's some things which we'll always see as serious. So that's dishonesty, financial impropriety, abuse of trust, or sexual or violent misconduct. Those are the more serious end of what we look at. We can, of course, also look at contextual mitigation. So increasingly, we're going to take into account the systems in place, the environment the events took in place, and the responsibility or control the individual had over the matters in question. And that might include medical concerns, including mental health concerns. We're alive to this issue often coming up in the context of an investigation. Ideally, we want solicitors to help report any health concerns to their employers, and if necessary, if it affects their practice and can't be managed, to us as well. But realistically, we often only find out about this after something has gone wrong. And we have recently done a consultation, which closed earlier this year, on improving the clarity of what we do when health issues are a factor. And that might include, for instance, putting conditions in place which help manage those concerns. So that's likely to result in new rules and guidance later this year. So again, do look out for that. In terms of action against in-house lawyers, you'll be pleased to hear there are limited examples, as I said, but just to walk through a few, you'll note that these all come out of some sort of public-facing element, either a criminal conviction, a public inquiry, or some sort of misconduct in personal life which has come to light. So the examples on the slide, SRA and Brett actually came out of a Leveson inquiry. This, in short, was an in-house lawyer who had allowed a statement to go into court, essentially that the allegation, the identification of the anonymous blogger wasn't based on any hacking or illegal access of comms, but it became apparent during the course of the Leveson inquiry that that lawyer had previously been told that the reporter had got that information due to hacking, and the SDT proceedings proceeded on the basis that, or resolved on the basis that he'd recklessly allowed the court to be misled, and he got a suspension of 6 months for that. And it's relevant to note that obviously if he'd been found to be dishonest, which requires a slightly different level of proof, but is obviously, you can see how those facts could have been different. They would normally be struck off. Moving forward to Mr. Bush, he was formerly General Counsel of Volkswagen Financial Services, so doing some leasing work. And he admitted that he'd suggested his close relative could do some work processing speeding notices when they couldn't find anyone else to do it. He approved, all those invoices got approved before he told anyone that he was connected to that person, and the fees did appear to be quite excessive. He left VFS in 2019 and was fined £2,000 for acting in an own interest conflict in that respect. And then lastly, Mr. Ackrell was got caught up in, but I think that's putting it too lightly. He acted as essentially a puppet director and the titular head of legal for what was in fact a sham property scheme worth over 16 million. Foreign investors pumped in about 16 million pounds in expectation of a 10% annual return, but in fact the proceeds from those sales went to purchase other sales and also the luxurious lifestyles of the scheme owners. And he lent, as a lawyer, lent this whole thing a veneer of respectability, which is a concern we've seen happening repeatedly, sadly. He was involved intimately in this and was struck off for dishonesty, as well as being ordered to pay £41,000 in costs. So, as I say, dishonesty generally leads to a strike-off. Without wanting to sort of prejudge anything, we may see some more in-house lawyer enforcement work in the next few years, insofar as anything else comes out of the woodwork relating to governance, relating to the post office. That's the sort of case that we might see in the future, and do look out for those as and when they come out. So a few other regulatory updates, and then I'll pause for questions. There's lots of things that we've been doing this year, but those that are probably most relevant to in-house solicitors on the next slide. To mention, we're proposing to restore the annual keeping of the role exercise. The role of solicitors is separate to your practicing certificate, and so this is a separate application, although I think if you're getting a practicing certificate, you basically will do it at the same time. But it is relevant because not all in-house solicitors we know need to have or do have practicing certificates. So you would still need to respond to the keeping of the role exercise, even if you're not applying for a practicing certificate. The other thing I wanted to mention is the wellbeing consultation. I've already mentioned the rules about our health processes. The other new proposed rule to mention is one on fair treatment. This is again to support our work around positive working culture and avoiding unfair treatment to colleagues, which can have an effect on regulatory outcomes. The proposed new code rule is that you should treat colleagues fairly and with respect. You will not bully or harass them or discriminate unfairly against them, and you challenge behaviour that does not meet this standard. Generally, we've got positive feedback on that. Certainly, the first few things we're pleased to say are largely uncontroversial as things that you should be doing. We've had a few discussion points around the requirement to challenge the behaviour. We think that's important, but the current proposal is that will be limited to managers. But we would encourage people generally, obviously, to challenge behaviour which is bullying, harassing, or discrimination. And again, hopefully that's not too controversial. Some other work we've done, I mentioned some of our research. This, when we've done it, is generally published. So we've done a piece of research into legal sector innovation, which covers what can be done by firms and others to seize some of the law tech opportunities available. We do a risk outlook for the profession, which focuses on things like information security and cybercrime. And we publish research on equality, diversity and inclusion, which includes not just surveys of attitudes to things like maternity pay and workplace adjustments, but also links through to our guidance on specific issues. In terms of guidance, again, I've mentioned supervision guidance, which hopefully will be coming out soon. On the next slide, there's a few other things which I've sort of suggested as possible topics that we might look into in the future, and we'd be really interested to hear your take on what you might like to see, what you think would be helpful to promote compliance. Say there's a few suggestions there, but maybe we'll come back to those ideas and questions. I've also got on one of my final slides an email address for one of my colleagues who is leading some research into this area, and would be grateful of any input from in-house solicitors on what that should cover or could cover, or helpfully we might say. So mindful of time, I'll get to the last slides, which are just about those resources. So we publish guidance on our website. There's a clear process for enforcement if ever you need that. We have a professional ethics helpline, which is mentioned there. That can be used for any queries relating to ethical compliance or how to comply with our rules. And we do publish research and reports. We also, as I mentioned, have some resources for those going through the SQE. Again, the link to that is on that slide. So hopefully that was helpful and informative, and I'd be happy to answer any questions which you may have.
Well, there have been a lot of very interesting questions. We won't have time to get through all of those, and apologies to anyone who is down as an anonymous attendee. Certainly we won't be able to respond to you specifically, but just a general question: if people have got specific concerns about matters within their businesses, is it that general guidance helpline is the best thing for them to go to?
Yeah, our ethics helpline is available. It's very responsive. You know, they're well informed about the specific rules, and that's of course if you can't find the answer through guidance on our website.
Yeah, well, there's quite a number of queries which relate in one way or another to navigating potential conflicts of interest within group structures and stuff. So if there's specific stuff there, then call the helpline, since I don't suppose there'll be one size fits all. So I'm going to just choose a few which seem interesting to me. So apologies if they're not interesting to anyone else. Someone who's an anonymous attendee has raised an interesting point, indicating that they think it would be helpful if in-house lawyer employment contracts there is a clause which says that the solicitor has an overriding duty to comply with their regulatory requirement. Is that something which the SRA can encourage businesses to adopt? Is that something that's being looked at?
It's been, I'm aware it's been proposed, because it's been proposed as by some academic research following on from the post office incidents. So it's something that we're thinking about. There's a slightly broader piece, which is that we don't necessarily regulate the firm that is employing you. So whether or not that we can do that within our remit is an open question, and the remit might have to change for us to do that. There are other ways we could do that, but that involves sort of imposing a further obligation on the solicitor who's already struggling with it in the premises. So we'd have to think quite carefully about that. But it's certainly a live issue, and I think I'd be very interested to hear any feedback as to how in-house solicitors who moot that would be useful, appropriate, and part of good governance. How they get on with those discussions, insofar as you could tell us.
An interesting and specific question was the topic of the new wellbeing rule on fair treatment. Is there an expectation that managers subject to grievance for bullying and harassment should be reported to the SRA simultaneously, or only on conclusion when any grievance has been upheld? What's the SRA's preference and ability to deal with these things?
So we will be publishing the guidance when the rules come out, which will address that issue, I think, because it's an obvious question. I think the existing case studies we published on wellbeing illustrate that we're not going to take action, and it's not going to be a serious regulatory breach every time there is, for instance, an employment tribunal or an employment dispute, and we're not sort of wanting to wade into the civil arena in that sense. So to some degree, it is going to depend on a judgment call as to the seriousness of the allegation. Again, our guidance will support with that when it's published. And if in doubt, you can ring our ethics helpline. They're particularly used to dealing with questions around when to report and also conflicts of interest. So those are good things to talk to them about.
Excellent. One interesting question from another anonymous attendee. How does the SRA approach compliance where matters are within the control of our employer, e.g. confidentiality of records on IT systems, shared office space, those sorts of things? How do you regulate and or help regulated solicitors in that situation?
I think that, well, firstly, I think that will be a very interesting thing for my colleague to look at when we're looking at in-house lawyers research, because we want to take your views on how that works in practice, and particularly the sorts of issues like, you say, confidentiality, which you might come across. I think in general, we're always going to take account of the degree of control a solicitor has over the scenario when considering whether or not there's any need to take any regulatory action in respect of it. That's as true in our house as is for firms. We often get scenarios with junior solicitors who are doing things wrong but have no control over it. But you have to take that in context, because, of course, the example I gave earlier of being asked to backdate a document, I think we would reasonably say, as a solicitor, you should be able to say no to that, regardless of whether or not you've been asked to do it. So, in terms of sort of your systems and controls and procedures, that's one thing. But if you're actually asked to do something unethical, I think we'd always have to say you have enough control that you should be able to say no to that.
Thank you. Now we've had a question from who says, are you able to speak to workplace culture in the Liverpool City Council example and the Jeanette McLaughlin case? And she's shared a URL to a Gazette article, which I've not looked at, but in the URL it mentions lawyers at crisis hit Liverpool City Council put under unacceptable pressure. Is that a subject you can expand upon in a useful way?
I'm not familiar enough with it to extemporize now, I'm afraid, but I will have a look at that afterwards if you want to forward me that link, because it's yeah, we're still sort of developing our thinking on this in terms of what we might say in our guidance in particular. So it's worth looking at any of those examples. But I think it's fair to say, if we can talk generically, that there are various examples of poor workplace cultures that we're concerned about, and I think our recent study showed 75% of solicitors responding to that said they worked in generally a positive environment, but that means 25% didn't, and it also means there's still concerns around bullying and harassment. So we're looking at improving those cultures for those we regulate as best we can, and avoiding the sort of regulatory outcomes which can arise from poor working cultures. But I don't know to what extent, having not looked at that particular case, it might seg a bit into that earlier question around to what extent do we regulate employers of in-house solicitors, and what can we do where we don't.
Yeah, but look, we're slightly running out of time now. So what has also been suggested is that we should probably do a Q&A document with gathering some of these things together, and hopefully Oliver might be able to give some links or give some response, since we are short of time, if that's okay. Oliver, were there more slides you wanted to refer anyone to before we finish?
I think we can share the slides afterwards. I didn't quite get to the end of them, but the rest are about our corporate strategy for the coming year. So if there are any questions about that as well, then that's fine. But yeah, most of that's very straightforward and published on our website, so that should be fine.
There were a couple of observations about just so you know, I've used the website to look for material, and the headings are not very helpful. Will you please publish a full copy of the documents as complete documents? That would be really, really good. So there you are. There's some customer feedback for you.
I'll capture that and let our IT comms team know. Okay.
Well, thank you very much indeed, Oliver, for that talk. It was indeed extremely interesting, even for me as a private practice lawyer, and it's very interesting to explore some of these issues. I hope everyone attending also found it worthwhile and interesting.